A Japanese court once wrote down inside its own judgment everything it did not have. No confession from the accused, no witness who saw or heard the poison being given, no trace of where that poison had come from, no sign of how the container was disposed of. Then, a few lines later, the same court declared the facts sufficiently proved and sentenced a man to death. He spent the next 27 years under that sentence, insisting he had killed no one. He was never executed. He was never cleared. He died at 86, still waiting for a court to look again. Almost no one outside this country has ever heard this story, yet it changed the mind of one of the most powerful judges in it. Hasaki sat at the southeastern tip of Ibaraki Prefecture, where the Tone River emptied into the Pacific. Pine windbreaks, small fields, a fishing harbor, and roads that had never been sealed. It was a town of farmers and fishermen, and it ran on wooden crates. Fish and vegetables moved in them. A man who sold those crates was a fixture of ordinary life, and in a place that small he needed no surname. Everyone called him the Boxman. He was 46 that summer. He had come home from Siberian internment after the war, settled in the town with a common-law wife, and pieced together a living: crates, radio repairs, and a sideline brokering land. He was literate, stubborn, and famously willing to argue with anyone who crossed him. The man who died was younger, in his mid-30s, a farmer with a wife and a serious money problem. He had sold off fields and woodland, drove without a license, had already rolled a car in a bad crash, and worked the area as an unlicensed taxi. What happened in that town in August never reached the national press at all. On the evening of August the 25th, the farmer was out late trying to raise cash, carrying his land title deeds with him. A little after midnight, he called at the Boxman's house. On that much, both sides of this case have always agreed. What the prosecution said happened next is this: the visitor complained that he was too agitated to sleep. His host gave him a capsule, describing it as aspirin. Inside, it was a cyanide compound. Then the host lent the unlicensed man his car for the short drive home. By about 1:15 midnight, the farmer was back at his own house, and something was badly wrong. His wife asked whether he had been drinking. According to her, he answered that he had been made to swallow medicine, 2 first, then 1 more, and he named the man who gave it to him, not by his name, but by the name the whole town used. "The Boxman tricked me." She testified that he repeated it 3 or 4 times. He was taken to hospital and died roughly an hour after he first collapsed. The physician who had worked on him signed the death certificate that same day. The cause he recorded was acute left ventricular failure, a heart that had stopped doing its job. That should have been the end of it. A man in debt, driving himself into the ground, dead of his heart at 35. Days later, a judicial autopsy replaced that finding with a different one: oral poisoning by a cyanide compound. The police opened a murder investigation. Everything contested in this case grows out of the gap between those 2 documents. Start with what a cyanide compound does to a human being. Taken by mouth in a fatal dose, it works fast, ordinarily killing within about 15 minutes. And it takes speech away almost immediately, because the body loses the ability to use oxygen at all. Now set that against what the record says happened in that house. The man lived for roughly an hour after he collapsed. In that hour, he did not simply groan, he spoke. He gave his wife a full account of what he believed had been done to him, named who had done it, and repeated the accusation 3 or 4 times. There is a third detail. Cyanide compounds carry a distinctive smell, often described as bitter almonds. The doctor who treated him did not notice it. And there is a fourth, the most difficult for the prosecution because it comes from the autopsy report itself. 2 lines from it were read into the trial record. The first, the findings in this body present, for the most part, the picture of acute death from cardiac insufficiency, and only 2 secondary signs faintly suggest death by poisoning. The second is shorter. The cyanide poisoning presentation in this body, the report says, is somewhat atypical. Then there is what was never found at all. Prosecutors never established where any poison had come from, never showed that the accused had ever possessed any, and never located a container. None of this proves that nobody poisoned that farmer. What his defenders argued, then and ever since, is narrower and harder to answer. That on this evidence, the state had not proved a homicide at all, and that a death from illness or from the despair of a man drowning in debt had never been ruled out. That is an argument about proof, not a claim to know what happened. About 2 months after the death, the boxman was taken into custody, not for murder. He was held on an allegation of forging private documents. The maneuver has a name there and a long history of criticism. It is called Beken Taiho, pretext arrest. You detain a suspect on a minor charge you can easily prove, then question him about the serious crime you actually care about. The murder arrest followed. In November, he was indicted with an unrelated attempted murder allegation from 4 years earlier attached. The forgery charges were real, and they matter. He had forged life insurance paperwork for 2 acquaintances, naming himself or his partner as beneficiaries. Those convictions survived every appeal. Anyone telling this story as a portrait of a blameless man is not telling it accurately. And there was a policy on the dead farmer's life worth 6 million yen, naming both the boxman and the widow as beneficiaries. At a time when a university graduate started work on about 10,000 yen a month, that was roughly 50 years of pay. It is easy to see why prosecutors found their motive there. The defense answer had 2 parts. The farmer owed him money and lived recklessly, so the cover existed to protect a loan with the borrower's agreement. And the money picture cut the other way. A railway employee testified that he stood to earn about 3 million yen in commission on a land deal then in progress, half the policy and entirely legal. The first trial ended on the 24th of December, 1966, at the Tsuchiura branch of the Mito District Court. Guilty of murder, of forgery, and of the earlier attempt. The sentence was death. The judgment is the reason this case is still argued about. Here is what the court itself set down. There is no confession of the defendant. There is no witness who saw or heard the poison being administered. The source of the poison and the method of its disposal are likewise unknown. And then, having listed all of that, we cannot possibly think that the perpetrator was anyone other than the defendant. The facts found are therefore sufficiently proved. The court had an explanation for the emptiness. It should be seen, the judgment says, as an attempt at what is called the perfect crime, leaving absolutely no evidence. 7 years passed before the appeal was heard. In that time, the condemned man wrote out an appeal brief by hand, about 80,000 characters long. The lower court had held his lack of remorse against him. What, he asked in writing, is an innocent man supposed to repent of? In July 1973, the Tokyo High Court found that his alibi on the older count held and acquitted him of it. On the poisoning, it upheld every finding below and imposed death again. A reporter in the room wrote that he went white as the acquittal was followed in the same breath by the sentence. On the 1st of April 1976, the Supreme Court dismissed his final appeal. 12 years and 8 months after that night, the sentence became final. Sitting on the bench that day was Shigemitsu Dando, the University of Tokyo scholar whose criminal law textbooks had trained a generation of prosecutors and judges. He had supported capital punishment. As the ruling was delivered, a voice came from the public gallery. Dando understood it as a single word thrown at the bench: murderer. He wrote later that he had already been carrying what he called a shadow of unease about the case. The defendant had denied it from the beginning, and he himself had lacked absolute confidence in the finding of guilt. He dated the turning of his own mind to that moment, and spent the rest of his life arguing that the state should not hold the power he had just used. His book on abolishing the death penalty is still the standard text there. Nearly 40 years later, the man who shouted came forward. He was the founder of the support group, by then 87 years old, and he said that he had never used that word at all. What he had called out was a question: "Are you going to put an innocent man to death?" He admitted he had said it loudly and accepted that it might have landed as an insult. He tried to telephone Dando at home to tell him so. Dando was out. The two men never spoke. Meanwhile, in the detention house at Kosuge, the years went by. Executions there are carried out with no advance warning. In a letter posted in December 1987, he described what that does to a person. "Every day except Sundays and holidays," he wrote, "is a continuing hell in which each time the door is rattled open, I feel a terror as though my heart will burst." He sent 235 letters and cards to the man who led his support group. 2 petitions to reopen the case were filed and dismissed for want of new evidence. His kidneys failed slowly. In his last year, he was on dialysis and largely bedridden. He applied for a pardon. His lawyers went to the bar associations and to a member of parliament, and his condition was raised in the National Assembly. Nothing was granted. He died in the early hours of the 3rd of September 2003 of chronic renal failure. He was 86. A third attempt to reopen his case was still being prepared. Set aside for a moment whether this man poisoned anyone. Look instead at how the same set of facts produced 2 completely opposed conclusions, because that is where this case earns its place. Both sides agree on the absences: no confession, no eyewitness to the act, no traced source for the poison, no container. The disagreement is about what an absence is worth. The court's reading treats emptiness as a signature. If a killing has been carried out and nothing at all remains to show it, that very thoroughness points to a planner, an attempt at the perfect crime. On that logic, the harder the case is to prove, the more it incriminates. Some have pointed out the obvious difficulty. An inference shaped that way cannot be argued against, because every missing piece of evidence becomes further proof. The defense reading is the ordinary one. Absence of proof is simply the state failing to carry its burden. It does not establish innocence, it establishes that the case was not made. 2 readings, 1 record. So test them against something neither side controls. Take the hour. On the prosecution's account, the farmer swallowed a lethal dose of a fast-acting poison shortly after midnight, then traveled home, spoke coherently for an extended period, delivered a detailed accusation, repeated it several times, and died about an hour later. Every one of those steps runs against how the substance in question is understood to behave. The courts accepted the accusation spoken in that hour as central evidence, while the pharmacology of the poison it convicted him of using suggests that hour should not have existed. Then line up the 3 documents the state produced in order. The treating physician wrote cardiac failure. The autopsy wrote poisoning and called its own presentation atypical. The judgment wrote that nothing had been found and convicted. Each document qualifies the one before it. No court ever reconciled them with each other. That is the strongest thing that can honestly be said here, and it stops short of a verdict. Not that he was innocent. No court has ever found that, and this video does not claim it. Only that the reasoning which held him under sentence of death for 27 years never had to answer its own contradictions, and never did.
He was never executed. He was never exonerated. Both of those things remain true today. The law there allows a retrial to be sought on behalf of someone already dead. His supporters intended to do exactly that. It has never been filed. By 2023, the group was down to 2 active members. Its founder had developed dementia, and the others had died or fallen ill. One of the 2 who remained said it should not be like this, but that he no longer had the energy to keep going. So the conviction stands, exactly as it was left in 1976. 63 years after a man collapsed in his own house, the questions raised by that judgment have never been answered. A judgment that lists what it does not have and convicts anyway. Would you call that proof? What do you think?